USCIS issued an update to the EB-2 NIW policy manual through a policy guidance that was published on January 15, 2025. In this video, we're going to discuss these updates and talk about the future of EB-2 NIWs. My name is Ingrid Perez. I'm an immigration attorney and founder of IBP Immigration Law. I file a lot of EB-2 NIWs, and I'm here to break it down for you. If you're considering filing an EB-2 NIW petition, you can also go to the link in my profile or go to my website and request a free case evaluation. Let's get to it. The EB-2 NIW is what I call a subcategory to the EB-2. There are 5 categories in the employment-based immigration space, categories 1 through 5, and within those, there are subcategories like the NIW. There are 3 ways to qualify for the EB-2 classification. I'm not talking about the NIW yet. I'm talking about the second preference classification. The updated policy manual makes this explicit and reminds people that first, you have to show USCIS that you qualify for the EB-2 classification before they'll even consider a national interest waiver. Now, the first way to qualify for the classification is by being a member of the professions holding an advanced degree. This means you have a master's or a doctorate degree required for your profession. If you have a degree from abroad, this degree must also be equivalent to a US degree in order for you to qualify. If you don't have an advanced degree, you can still qualify by having the equivalent, which is a bachelor's plus 5 years of experience in your profession. And the policy update is reminding us that there needs to be a nexus between your degree and your endeavor, and your endeavor needs to be a professional endeavor. And USCIS gives us an example. So let's say you have a PhD degree and your endeavor is to open a bakery. That's not going to work. You don't need a PhD to open a bakery. There's no nexus between your degree and your bakery. If you're qualifying based on your bachelor's degree and your professional experience, and let's say you have a bachelor's degree in biochemistry, but your experience is in the restaurant industry, that's also not going to work. The same is true if you're trying to qualify for the EB-2 classification through exceptional ability. You have to show that your exceptional ability is in the field of your endeavor. So all of the evidence that you use to show this must be related to your profession. The National Interest Waiver is the framework that allows people to bypass the requirement of a labor certification and a job offer. It was fleshed out in that very famous case, Matter of Dinosaur, that came out during the Obama administration. President Biden then issued a guidance for STEM workers in January of 2022, and now January 15, 2024, Biden issued this new guidance, which I presume is because USCIS had buyer's remorse over everyone starting to submit EB-2 NIW petitions by virtue of having a STEM degree. There are essentially 2 types of NIWs, which are not explicit in the regulations, but I think are important to identify for the purposes of this discussion. I'm talking about NIWs for what I like to call industry professionals and NIWs for entrepreneurs. Industry professionals can include people like researchers or other professionals, and entrepreneurs are those who endeavor to run a business in the US. The first prong of the NIW is national importance and merit. And the guidance is basically saying that if the benefit is to your employer, even if your employer is engaged in something that is important to the United States, that's not going to work for an NIW. So for example, if you're an engineer and you work for a company that engineers technologies for US defense, they don't care. They think you're just contributing to your employer, even if your employer is engaged in something that is important to the US. The policy guidance also says that your own individual endeavor must stand to have broader implications, such as those for a field, a region, or the public at large. The sample they give is a person developing a drug for a pharmaceutical company. They may establish national importance by showing the prospective public health benefits of the drug instead of relying on just the profits that the employer is going to get out of this drug. Another example they give is a person developing a specific technology that's going to be used by a company to sell to its clients. If the benefit is being felt by the company's clients, that may not work for an NIW. In this scenario, a person may be able to meet the national importance if they can submit evidence of the widespread use or licensing of some novel technology, or maybe an important manufacturing or operational process. For entrepreneurs, the new guidance is saying that there are unique considerations for EB-2 NIWs. And I do think, though, that this is a response to many people who submit entrepreneurial endeavors because they're mainly outside of the United States, and maybe they don't have the right guidance to propose an endeavor that makes sense for their specific case. I do see a lot of this with industry professionals who are outside of the United States and are submitting business plans to USCIS, but they're not entrepreneurs and their experience has nothing to do with actually running a business. In this scenario, USCIS is going to question whether you are well positioned to advance your entrepreneurial endeavor. And for entrepreneurs, the new guidance is expanding a lot of those things that generally impact entrepreneurial endeavors. So for example, general economic contributions are not enough. Simply saying that by having a company, you're going to employ people and also contribute to the US economy, that's just not going to be enough. You have to show specific impact, such as industry-wide advancements or helping solve a problem, and not just general claims, like you're going to create jobs and economic movement. You also need to provide detailed evidence. The new policy talks about all the different substantive evidence that you can submit to prove merit, importance, and feasibility of your endeavor. So for example, evidence that you have a central role in the endeavor, like you're the owner, the founder, or major stakeholder in this company. It's also really great to show that your endeavor and what you're saying is for real. So for example, maybe you have venture capital, angel investors, or money to invest, or money that you have already invested. Maybe you have been accepted into a reputable accelerator program to help develop your endeavor. It's also really important to show that your business is going to generate revenue, create jobs in underserved areas. That is really great for an NIW. If you have them, show your patents, trademarks, or any unique business model and their real-world applications through your business. Immigration is telling us that they understand that entrepreneurship is different and they're going to look at these petitions holistically. So this allows you to be a lot more creative with the types of evidence you submit. So my tip is focus on the national benefits and show how your specific endeavor through your business impacts a specific interest of the United States. To show that you're well positioned, USCIS is providing a non-exhaustive list of the types of evidence that can show you're well positioned to advance your endeavor. Now, this list is non-exhaustive, but I want to focus here on the letters of support because this is always a hot topic. USCIS is saying that the letters may be persuasive if they are from experts in your field who have firsthand knowledge of your achievements. They must describe the achievements and provide specific examples of how you are well positioned to advance your endeavor. They say the letters also must be supported by other independent evidence on the record. And they also say that if you have a business plan, that too should be supported by independent evidence. My takeaway here for you is that the best letters come from experts who know you, who know your work personally. But you also have to be careful with the letters because USCIS is notorious for saying that because the letters are from somebody that knows you, they don't hold a lot of weight because they are written for the purposes of the petition. This is actually a pretty common critique in EB-1A RFEs, where USCIS says that, well, these are people who know you, so of course they're going to say wonderful things about you. So my tip is really think about these letters as testimonials. Make them objective and less complimentary. For the last prong, I think it's really important to note that in the policy manual, USCIS is telling us that they're going to take the evidence you submitted for national importance and look at it together with the evidence that you submitted for well-positioned to make a final determination on your case. I don't think that this changes this prong too much. It's always how I've approached it anyway. And reading this policy manual, I think it's really important to understand that it doesn't seem like USCIS is putting too much weight on the STEM guidance from January 2022. And they don't really seem to care too much about the critical and emerging technologies list. They mention it briefly in the footnotes as a way to prove up this prong, but aside from that, it seems like USCIS is not putting a lot of weight on this, which goes back to my previous assessment that USCIS, I think, had buyer's remorse from the January 22 memo, and this new policy guidance confirms that. Nevertheless, if you want to pursue an EB-2 NIW, hope is not lost. There's still many ways to get an EB-2 NIW, and we just have to adapt to the changing landscape. My name is Ingrid Perez. I'm an immigration attorney at IBP Immigration Law. You can get a free EB-2 NIW case evaluation by going to my website and sending me your information.